Rivers State?
Yes, peace is what is required for democracy to even thrive, because when you go into the nitty-gritties as to whether or not the state of emergency was proper or improper, we're still going to meet crisis. You understand? We're still going to meet crisis, or whether what the House of Assembly did or did not do, or what the governor did or did not do. If we begin to probe all that after all this problem, we're still going back to the problem. So
I know you talk about, apologies for interrupting you, I know you talk about the state of emergency. For those who now say, because I spoke with someone from the state yesterday, she's in a civil society space, and she said, looking back, and this, I asked a high question about the state of emergency, and she said it does look like the end has justified the means. As long as now there's reconciliation and peace, they don't really have a problem with the state of emergency, because now there's led to peace in the state. Do you agree that somehow the end has justified the means?
No, I do not agree. From the standpoint of law, you don't use wrong to quell wrong. Okay, so what you call peace today is because there has been a state of emergency and now everyone has resumed. You understand? It's too early in the day to say that the state of emergency has quelled the crisis in Rivers State and has brought peace. It's too early in the day. Let's watch it for the next 1 year. Because you have 40 cases in court as we speak. So cases in court is dispute. Maybe the state of emergency, because these persons were sacked, they are no longer in the flashpoint. There's nothing they could have done. You understand? So it's too early in the day to say that there's now peace. Peace, you can only determine peace when people are still in their position and they have chosen to turn a new leaf. Not when they were sacked. There's nothing they could have done to continue the warmongering and the rest of that. So let's give it some time. If they have learned any lesson, the future will let us know about that. But as to the conclusion that there's now peace, I don't think it's a safe way to assess the issue as we speak.
So in terms of assessing the issue, we'll get back to Rivers State and its politics, but let's talk about the role that the judiciary played in all of this. Many believe, in fact, quite obviously, the judiciary played a role in exacerbating the crisis with various, in fact, sometimes from courts of what's that word again?
Concurrent
jurisdiction. With very different judgments on same matter. Just looking back now, what do you make of the role that the judiciary played in all of this?
Yeah, the role of the judiciary is to resolve disputes based on Section 6 of the 1999 Constitution. That's our primary responsibility. But you see, that role is very complex because you have litigants, you have matters before the court, and you have a lot of cases at the same time. But you see, these cases, they may look the same, but sometimes they are not exactly the same. Because a court will only give judgment or ruling based on the evidence before it. You understand? So if you have two cases in two different courts, and the evidences before those courts, or the evidence before those courts, are different, the outcome cannot be different. Cannot be the same, rather. The outcome cannot be the same. So that may have played a role. But ultimately, when you look at it, I do not think that given the level of dispute and the number of cases in court, the judiciary would have handled it more than they did, because there was a lot of confusion. 40
different cases still in court. That's a lot for just what would seem like a very simple issue to resolve.
Yes.
But doesn't the judiciary have the power, the moral standing to say, look, it's a court of concurrent jurisdiction. It's not like you went to the appeal or the Supreme Court.
Yes.
If the High Court in Rivers State, for example, is sitting on one matter, shouldn't the High Court in Abuja, for example, say, well, let's wait for the judgment from Rivers and then we'll see how that
The High Court in Rivers State sitting on a matter can only do that when they have jurisdiction. You understand? But when it has to do with dispute between institutions of government, the High Court does not even have jurisdiction. But in Rivers State, the High Court were entertaining matters that is outside jurisdiction. And when they give a ruling there, the other party goes to the Federal High Court and starts another matter. So there was a lot of convolution. It's not just the law court, but the lawyers were also filing these cases. And the lawyers were also advising these parties. Because when a case gets to a court of law, the court must first assume jurisdiction to determine whether it has jurisdiction to hear the matter. And we saw that all over in these cases. Why one is ending, another one is starting. There were appeals, remember? There were different matters filed for different purposes all together.
And in that conversation you and I had, I think it was with Anosike, I think so, who was holding on very tightly to the judgment given by Justice Omotosho. And then there was another one given by, I can't remember the chief judge now, in Rivers State. And so it was different judgments on the same matter, but everyone held on to theirs. Yes. Doesn't the judiciary have the ability to regulate itself and sanction every judges and lawyers? It has
the capacity to regulate itself and sanction, the agency sanction judges accordingly. You understand? And while that case was ongoing, we saw a lot of that happening. There are times when petitions were flying up and down against judges within that same circle. But because the judiciary regulates from within, it may not be in the news, it may not be in the public glare, but the judiciary, the NJC definitely looked at all this matter. That is why, that was why they came up with this issue that if you are filing a matter, you must file an affidavit of non-duplicity to state that while you are filing this matter has not been filed in any other place. To avoid forum shopping, where people will go file one here, file one here, file one here, and then begin to determine among the three judges who is likely to give judgment in their favor. So if you are filing a case, you have to be on oath to state that this matter has not been filed in any other place. That's why they introduced that from the rule book and all that, to regulate conduct of lawyers who have the tendency and proclivity to want to create multiplicity. And then you start to have problems from different angles.
And there are those who say, look, the 40 different cases have now been overtaken, events have overtaken them. And perhaps, everybody should move on, even with the one at the Supreme Court. I mean, what would be your reaction?
In the spirit of settlement, I think that the ones before the Federal High Court and all that should all be withdrawn. But I don't think the one in the Supreme Court should be withdrawn, because it gives us another opportunity to determine whether or not the president can remove a sitting governor. Because the last time we had this before now was in the case of Joshua Dare in Plateau State, where the state of emergency had been declared by Obasanjo, and the Joshua Dare, the governor, had been, and the Attorney General went to court, you understand, to challenge the propriety or otherwise of that action. And the counsel to the government brought an action before the court and said that he's no longer the Attorney General and he cannot file a case on that ground. So the preliminary objection was upheld by the court. And so the matter didn't go on. The substantive suit was not determined. Now, in 2025, another opportunity was presented to us for the Supreme Court to now state exactly what the matter is, so that we can have a precedent, so that going forward, the president will know where his power starts in Section 305 and know where it ends. Because the express mention of one thing excludes the other, and if in the section of the law that states that a governor can vacate his position by impeachment, by resignation, or by death, if that section did not in any way, in a subsection, state that in the state of emergency, the president can also, order a governor to vacate his seat, then it means that the Constitution, jurisprudentially speaking, never contemplated that. But that is my argument as a lawyer. We need to take it before the court, let the court adjudicate on it, because the law is what the court said the law is, and nothing more pretentious. So let the court determine it. And the matter is still before the court. Whether it has become an academic exercise or not, the Supreme Court should determine the matter. Since it has not been withdrawn, it's still before them. 5 months running, they've not. During the NBA conference, there was a call made by one of the speakers to the Supreme Court to determine that matter, so that going forward, a president, when we have precedents, so some people have argued that because the head of the judiciary is appointed by the president, it will be difficult for the CJN to do the needful and tell the president the truth. And I said, no, that shouldn't be an excuse. The judiciary should be independent, absolutely independent. And there's this further argument that perhaps we should tinker with the Constitution to take care of that lacuna, such that the head of the judiciary should emerge through a voting process. Just like, because it's only the judiciary that you have appointment. The three arms of government, the legislature, the executive,
Isn't
and
that
the judiciary.
supposed to be the most senior justice who just automatically fills in?
Yeah, the most senior fills in, but then he's recommended by the NJC, then appointed by the president. That's the process. Whatever other arm of government, they're elected directly from the electors, the electorate. So they have the mandate of the president have a mandate of the people, the members of the legislatures, they have a mandate of the board. For the judiciary, you have that appointment procedure. People have argued that in very civilized democracies, they can only be dispassionate and they can only act in the interests of the country in a situation where they emerge through a voting process, whether through the judiciary arm of lawyers voting them in, or you just create
a body of
a way to